Judicial appointment is a critical aspect of a country's judiciary, as it plays a vital role in ensuring the independence and impartiality of the judicial system. We will explore the judicial appointment process in the USA, Canada, UK, Australia, and India, and why the Indian judicial appointment process is considered anti-democratic. We will also critically analyze the Indian judiciary and its recent controversies, including the first and second judges' cases, which have further eroded the public's confidence in the Indian judiciary. In the United States, the federal court system is appointed by the President and confirmed by the Senate. The President nominates judges for appointment, with the Senate providing the advice and consent. This process ensures a balance between the executive and legislative branches of government and ensures that the judiciary remains independent and impartial. The Senate Judiciary Committee holds hearings to assess the qualifications and temperament of the nominee and their views on various legal issues. This process helps to ensure that the appointed judges are qualified, impartial, and independent. In Canada, the appointments to the judiciary are made by the Governor-General, on the advice of the Prime Minister, after consultation with the Minister of Justice. The Canadian government has taken steps to ensure that the appointments are made based on merit and are free from political influence. The government has established a Judicial Advisory Committee that provides recommendations to the Minister of Justice on potential appointments. This committee is made up of respected members of the legal community and is responsible for ensuring that the appointments are made based on merit and that the judges appointed are qualified. The United Kingdom has a similar appointment process, where the appointments to the judiciary are made by the Queen on the advice of the Prime Minister and the Lord Chancellor. The Lord Chancellor is responsible for advising the Prime Minister on judicial appointments, and the Prime Minister makes recommendations to the Queen. In Australia, the appointments to the judiciary are made by the Governor-General on the advice of the Attorney-General. The Australian government has established a Judicial Appointments Commission, which is responsible for advising the Attorney-General on potential appointments. When it comes to Indian judicial appointment system has been the subject of much debate and criticism over the years, with several key issues that have arisen. One of the primary concerns is the lack of transparency and accountability in the current collegium system, which is based on the appointment of judges by other judges. Critics argue that this system can lead to nepotism and the appointment of unqualified individuals to the judiciary. Another issue is the lack of role for the legislative branch in the appointment process. Under the current system, the judiciary has significant control over the appointment of judges, and there is limited oversight or input from the legislative branch. The National Judicial Appointments Commission was proposed as a potential solution to these issues, with the goal of increasing transparency and accountability in the appointment process. However, the NJAC was declared unconstitutional by the Supreme Court, leading to ongoing debates about the best way to improve the appointment process. It is also worth noting that the first and second judges' cases have played a significant role in shaping the current appointment process, with some arguing that these decisions have contributed to the lack of accountability and transparency in the system. Overall, the Indian judicial appointment process is an important issue that requires ongoing attention and discussion. To ensure that the judiciary is able to effectively serve its role in protecting the rule of law and individual rights and freedoms.